Good morning, this is your Kelso Report for Tuesday, November 29th, and I'm your host, Clark Kelso. Well, we have some one-liners and then some grants of review by the Supreme Court today. First, in the area of criminal procedure and grand juries, in Paccar versus Superior Court, the 2nd District held that the petitioner, who had filed a writ seeking extraordinary relief, did not establish that members of a grand jury, which had issued an indictment charging him with 3 counts of first-degree murder, was biased. The 2nd District avoided deciding the interesting legal question of whether grand juror bias is even a cognizable claim under California law, by holding that the petitioner failed to show actual bias in any event. The basis for the claim was that one of the grand jurors worked as a secretary for the Ventura County High-Tech Task Force, and some of the evidence in the case had been submitted to the task force for analysis many months before. The affected grand juror had disclosed her position with the task force, and under questioning made it clear that she did not believe her work for the task force made her unable to render an unbiased decision. There was no evidence that she behaved in a biased way, so the trial court found there was no evidence of actual bias, and the 2nd District affirmed. Well, now we turn from grand jury issues to juror misconduct. In People v. Angstrom, where the defendant was convicted of illegal cultivation of marijuana, the 3rd District held that jurors do not engage in misconduct by recalculating the anticipated yield of an indoor marijuana garden using a different number for the area covered by grow lights from an expert's formula. The court held that the jury did not use any extraneous materials or evidence, or conduct any improper experiment in making the adjustment, and that therefore there was no misconduct. Instead, the jury simply disagreed with the expert's conclusion that the grow lights would illuminate the entire room equally. The jury decided, based on a picture of the room, that the lights were focused only on the area where plants were growing, known as the canopy area, and the jury simply adjusted the calculations to reflect that reduced area, which had the result of substantially increasing the projected yield from the growing room. The yield was important because the defendant claimed he was producing marijuana for medical uses, but the evidence established he grew many times more plants than necessary for medical uses. His conviction was affirmed. Next, we have a civil procedure, an anti-SLAPP case in Somerville versus Randolph. The 2nd District held that an attorney affidavit filed in a foreign country's court to influence the result in pending California litigation qualifies for protection under the anti-SLAPP statute. Now, as you know, when a defendant files a motion to strike under the anti-SLAPP statute, the first question is whether the defendant has shown that the plaintiff's claim arose out of protected activities by the defendant. If so, then the burden shifts to the plaintiff to demonstrate a probability that he or she will prevail on the claim. In yesterday's case, the protected activity was the filing in a foreign court of an attorney's affidavit to take a late appeal of a foreign judgment, which, if granted, would have aided the attorney's client in a pending California case. The plaintiff argued that filing a document in a foreign country is not a protected activity under the United States or California constitutions, so the anti-SLAPP statute should not apply. But the 2nd District disagreed with this argument, since the foreign filing was intended to influence related litigation that was already pending in a California state court. The court held that was sufficient to trigger the protections of the anti-SLAPP statute. And the court also held that the plaintiff had made no showing of a probability of prevailing, so the motion to strike should have been granted. And now we turn to some Supreme Court grants of certiorari. First, in the area of criminal sentencing. In 2010, Congress enacted the Fair Sentencing Act, which increased the drug quantities necessary to trigger mandatory minimum sentences under the Controlled Substances Act and the Controlled Substances Import and Export Act. In particular, it adjusted the amount of crack cocaine necessary to trigger mandatory minimums. Well, in United States v. Fisher from the 7th Circuit and United States v. Hill, also from the 7th Circuit, we see two Seventh Circuit opinions which held that the Fair Sentencing Act applied prospectively only and did not apply retroactively to conduct that occurred prior to the effective date of the Act. The court granted review to examine that legal conclusion. Our next case involves a rule of evidence, or a ruling dealing with evidence, in United States v. Vasquez. The Supreme Court granted review to examine a rather narrow issue involving harmless error. The district court had admitted during the prosecution's rebuttal case a tape recording between the defendant's wife and a co-defendant. In the course of the conversation, the wife disclosed that the defendant's lawyer had advised him to plead guilty, and had said that if the three defendants went to trial, quote, everyone is going to lose, close quote. Well, all three judges of the Second Circuit panel agreed that it was error to admit this portion of the tape for the truth of the statements on the tape, which is what the district judge did. But the majority held that in light of other evidence in the case, the error was harmless. There was a dissenting judge who was not convinced beyond a reasonable doubt that the jury would have convicted the defendant absent the improper and highly prejudicial tape evidence, given the closeness of the case. The Supreme Court is going to decide for us just how close the case was. Next, in the area of labor law and who gets overtime, in Christopher v. SmithKline Beecham Corporation, the Supreme Court granted review to determine whether pharmaceutical sales representatives are entitled to overtime pay under federal labor laws, or whether they are properly categorized as, quote, outside salesmen, close quote, which makes them exempt from overtime pay requirements. The problem factually is that pharmaceutical sales reps never actually make sales, since only a physician may prescribe the drugs to a patient. Yet the sales reps certainly behave like, and are compensated in the same way as, traditional outside salesmen. The big legal issue in the case is whether the Ninth Circuit should have deferred to the Department of Labor's interpretation of the statute, which favored a conclusion that the sales reps were entitled to overtime pay. The Ninth Circuit held that because the department's interpretation was little more than a parroting of the statutory language, did not clarify any ambiguities, and did not evidence any attempt to use the department's expertise, the department's conclusion was entitled only to some respect, but not to deference. So this case presents a nice general question about the respect and deference which courts should give to administrative agency interpretations and conclusions. And our final cert grant is also in criminal sentencing, this time dealing with the imposition of criminal fines in United States v. Southern Union Company. The First Circuit held that the imposition of a criminal fine was not subject to the requirements of Apprendi v. New Jersey. In particular, the statute of conviction set a maximum fine of $50,000 for each day of violation. There were arguably as many as 762 days of violations, which would have resulted in a maximum possible fine of $38.1 million. Ultimately, the court imposed a total fine of $18 million on the defendant, and the defendant appealed, arguing that it violated Apprendi for the trial court instead of the jury to make the decision about the size of the fine. Now, it's going to be very interesting to see how the Supreme Court deals with this issue, since it seems unlikely that a jury is particularly well suited to exercising the very broad discretion that usually is involved in deciding how large a criminal fine should be. Yet it would seem to be a pretty logical extension of Apprendi's reasoning. So the court is going to have to wrestle with that conflict between logic and practicality. And that's it for today's Kelso Report. Have a great day in the law.